Mr. Barker?
Yes. Thank you.
Closing argument.
Thank you, Judge. The defendant couldn't wait to shoot his gun. He was eager to. Not a second thought to stay in his car, not a second thought to call the police or to drive away. Because his first thought was to fire his gun. His first thought was to retaliate. His first thought was to arm himself with a weapon and show whoever was out there who had the power. Because with that gun in his hands, ladies and gentlemen, he had the power over people's lives. Now, we know he was punched in the face. The state proved that to you. But what he did afterwards has nothing to do with self-defense and everything to do with retaliation. The defendant wanted to enact his own deranged sense of justice, not the justice we have here in this courtroom or that we swore an oath to uphold. No, he wanted to be the judge, the jury, and the executioner when he shot Colin Brew. Double tap at center mass, as he described it. Now, we just heard a moment ago the instructions, the rules that you must follow. This is the law. It's one of the most important parts of this case, because if you follow the law, then you will find the defendant guilty of first-degree murder. You will find him guilty of aggravated assault. Now, it goes by pretty quickly, so I want to talk about some of these instructions in a little more detail. And let's talk first about self-defense. And let's just dismiss this notion right now that self-defense has any application to this case, because it does not. And I'm going to prove it to you in 4 different ways. First, the instruction tells you that you can only use deadly physical force to protect against deadly physical force. Well, that's an instruction that's defined, or the definition of deadly physical force is defined for you as force that can kill someone. Force that is meant to cause that type of harm. The only person that night who was using deadly physical force was the defendant. He was the only one with a weapon. He had a gun in his hand. Nobody else that night was threatening deadly physical force. Now, we talked about this concept during jury selection. We talked about the idea of proportionality. Remember this discussion? None of you raised your hand when I asked you if it was okay to bring a knife to a fist fight. Well, here, the defendant brought a gun to what wasn't even a fist fight, but merely a verbal argument. Based on this factor alone, ladies and gentlemen, there is no self-defense. It does not apply. Now, there are other reasons. Let's talk about them. The instruction goes on to tell you that the use of deadly physical force ends when the apparent danger ends. That means that when the defendant was at his car and he realized by his own admission that he testified to that he was alone, there was no danger. At the point the defendant realized that there was nobody at his car and he decided to go back, to go 90 feet away from his car, he was the aggressor. This is a fundamental concept of self-defense. It's a concept that you all understand. Because if you're punched in the face at one point and you leave, that you voluntarily retreat, you can't then come back and punch that person back in the face. What is that? That's retaliation. But the defendant didn't just retaliate with his fists. He escalated it, and he came back with a gun. He wanted to teach someone a lesson. Again, this is not self-defense. For any of these reasons, by the way, self-defense does not apply. A related concept is the idea that it must be immediately necessary. Those are the words in your instruction. It must be immediately necessary to protect against deadly physical force. How far away was the defendant? When he got to his car, he was 150 feet away from where he was punched in the face. Then he went 90 feet back. At no point was he closer than 90 feet to those victims when he got his gun, until he decided to approach that corner of the parking lot. 240 plus feet round trip. There was nothing immediate about his reaction that night. When the defendant got to his car and discovered he was alone, there was no immediate need for any type of force, let alone deadly physical force. Again, for this reason, self-defense does not apply. Finally, the instruction tells you that the use of force must be reasonable. Reasonable. Remember, we had this discussion as well during jury selection, this idea that the standard for self-defense is not the subjective intent of the person using it. The standard is the reasonable person standard. It's an objective standard. And this makes sense, right, at a basic level, because if it was just based on what somebody thought, then murder would become obsolete. Everyone would say, well, I just thought it was self-defense, and we just have to take their word for it. But that's not how it works. It's based on what a reasonable person would have done in that situation. And there's nothing about what the defendant did that was reasonable that night. Again, we do not live in the defendant's world. He lives in the world of law and order, like all of us. Now, put in a kind of a visual perspective, in a population you'll have a bell curve. The reasonable person can be described as the person right in the middle. You as a jury represent that standard, the reasonable person standard. You are the voice of the community. Where does the defendant fit in this curve? He's out on the fringes. He's not acting reasonably. Now, how do you know what the reasonable person would have done in that situation? Well, you have a lot of evidence that you heard from approximately 15, 16 witnesses who were out there, who were watching, either from the Mountain View dorms, or on the street level, or from the defendant's own friends, Shay McConnell, Jacob Mike. How did they describe this situation? Did they describe it as a life or death situation? The young ladies in Mountain View dorm talked about how at no point did they feel the need to call 911 until the defendant showed up with his gun. They described it as a situation that didn't appear different from any other situation at a late night college campus type of argument. They weren't discussing or telling you about any weapons or any physical altercation. They were talking about a verbal altercation on a college campus late night. How did Jacob Mike describe it? The defendant's own friend, the one who was on the other side of that confrontation with the victims. What did he say? He said that at no point did he feel his life was in danger. How does Shay McConnell describe it? He said when the defendant showed up with his gun, he thought he was crazy. Is Shay McConnell describing a reasonable person? Of course not. Who is the outlier? Who is the one on the fringes? The defendant. He's the only person describing a situation that is life or death. A situation that in his own belief, in his own mind, at least what he's claiming, that he needed to use this type of force. Luckily, we don't have to rely on what the defendant says because we have a bunch of other people who were there that described it in a completely different way. Do not live in his world. This is not self-defense. Nothing he did was reasonable that night. Now, for all those reasons, or any of those reasons, self-defense does not apply. But if you needed any further proof that what the defendant did was not self-defense, what did he say it was that night? How did he talk about it? Because the defendant himself does not really believe he was justified. You remember what Nick Acevedo talked about? He said he was the first one that ran up to Colin. He was holding his friend. He was cradling him when he saw the defendant clutching onto his gun. And he asked him why. Why did you do this? And what was the defense response? I don't know. Not, it was immediately necessary for me to protect myself. Not, these guys were going to kill me. No, he said, I don't know. In that moment of self-reflection, the defendant was trying to figure out what world he lived in. This was not a video game. This was real life. He just shot two unarmed people. And his first statement to Nick Acevedo was, I don't know. What did Nick Plecki say about how the defendant responded? He said he heard the defendant say to himself, what did I do? Again, is he describing to anybody that this is a justified situation? Of course not. And then later, of course, we heard from Deputy Labarro talking about how after he was arrested, the defendant, he was put in the back of that patrol car. Deputy Labarro was standing guard outside that car. And the defendant told him, nobody did anything wrong but me. This is a confession. He's admitting right there that he did something wrong. He's not discussing that he was justified. He's not saying that what he did was correct or right. arrested for a reason, that what he did was wrong. Now, it wasn't until later, of course, when he had an audience with the police in a police station on the record that he started talking about, well, these people are trying to kill me, right? But in that moment of introspection, he knew that what he had done was wrong. Even the defendant doesn't believe he's justified. Well, if it's not self-defense, what is it? It's first-degree murder. And here's why. The jury instruction that you have defines it. I've summarized it here. The first element the state must prove to you is that the defendant killed Colin Brew. Well, that's undisputed in this case. Correct? Nobody's saying that he didn't. In fact, the defendant testified that he intentionally shot Colin, and the defendant said that Colin Brew in fact died as a result. The second element is, did the defendant know his conduct would cause death, would cause Colin Brew's death? He talked about, we went around on this issue a little bit. He talked about how a lot of the times shots to the chest are fatal, right? And how many times did the defendant shoot at Colin Brew with that .40 caliber with the mushrooming rounds? Twice in the torso. Now, there's an instruction that talks about how intent can be inferred from all the facts and circumstances. You do not have to rely on direct sensory proof. You wouldn't expect the defendant to get up there and say, everything I did was premeditated, right? So you have to look at the facts and circumstances of the case. The fact that he chambered the round before he walked at 90 feet. The fact that he shot Colin Brew twice at center mass, a double tap as he described it. You bet he knew what he was doing. You bet he knew his conduct would cause death. This third element the state must prove is that he acted with premeditation. Now, this is a concept that is misunderstood, probably because of the movies or TV or the news. Sometimes you think that premeditated murder means that someone's in a dark basement with schematics and they have a plan sometime in the future to kill somebody. And that's not what's required under this rule, under this instruction. Premeditation can be summarized this way. Defendant knew he would kill another human being, and after forming that knowledge, he reflected before killing. It's that reflection that distinguishes first-degree murder from second-degree murder. Did the defendant have an opportunity to reflect? You bet he did. After he was punched in the face, where did he go? He went 150 plus feet to his car. Why? To get his gun. What did he do when he got in his car? Did he drive away? No. Did he lock the doors? No. Did he call the police? No. He got his gun out of his glove box and he chambered a round. Did he have an opportunity to reflect in that moment? And then he walked, again, he walked 90 plus feet back to the corner of that parking lot where the victims were. Did he have time in that space to reflect on what he was about to do with that loaded gun? Even in that moment, right before Colin Brew stepped up to him or confronted him or lunged at him, whatever you want to call it, did the defendant have an opportunity to reflect about what he was about to do with that loaded gun? That he had prepared himself to shoot someone. Now notice that in this instruction, there is no element that the state has to prove that he is evil, diabolical, cold-blooded. You remember the defense attorney getting up in opening statements saying that the state wants you to believe he's a cold-blooded killer. Well, cold-blooded was never our word. Does the defense want you to believe there's some other standard out there that we have to prove he's now cold-blooded as well? That's not what is required under this instruction. You're not here to judge somebody's character, but their actions on a specific night. The other words not included in here: plan, preparation, deliberation. It's not required either. All that's required is that there was a moment of reflection before the defendant decided to kill Colin Brew. And again, as I said before, you can infer that from the facts and circumstances surrounding this event. The fact that the first thing he did was to get his gun out, and then to chamber a round, and then to go back 90 feet. And that the first person who decided to step up to him, who dared confront him, got 2 shots to the torso. Now, this moment of reflection can be very short. In fact, that's what the instructions tells you. The space of time between the intent or knowledge to kill in the act of killing can be very short. Now let's put it this way. Let me give you an analogy. All of us have had the experience of driving down the street and get to a stoplight, and that stoplight turns from green to yellow, and we have to make a decision, right? Are we going through the intersection, or are we going to stop before the intersection? Now that moment where we reflect upon that decision is short. It can happen really quickly. We've all had this experience. And now, to take this a little further, sometimes we make the wrong decision, right? Sometimes we decide to go through the light and it turns red before we cross the lines, and there's a police officer, he pulls us over, we get a ticket, maybe we feel bad about what we had just done. But that does not undo the decision we made to run the light. Likewise, whatever regret the defendant may have felt after he shot Colin Brew does not undo the decision he made before. It does not undo premeditation. The state has proven to you that the defendant killed Colin Brew, that he knew his conduct would cause death, and that he acted with premeditation. Now, during this case, the defense has talked a lot about possibilities. They've asked questions. Is it possible that Colin Brew's hands were past the muzzle of the defendant's gun when he got shot? Is it possible that somebody may have heard the word kill even though nobody talked about it? Is it possible that Xanax and alcohol make people very big and scary? So many things are possible, right? But we're not here to talk about possibilities. We're here to talk about what actually happened. Those are the words, in fact, in your jury instruction. You're here to determine what actually happened. And what actually happened is what the state told you in opening statement, and it hasn't changed throughout this trial. It's remained the same story. What actually happened that night was on October 9th, 2015, the defendant and three of his friends, Shane McConnell, Jacob Mike, and Hunter Todd, decided to go to a party at the Grove. The defendant was driving his car, this red Malibu, or excuse me, not Malibu, but Mustang, parked it right in that stall, right where the police found it. And then they walked up Franklin Avenue. We've seen this many times. Up toward the Grove. And at the same time this party was happening, there was that party at the courtyard where the victims were. And there was alcohol at both parties. And the victims were drinking that night. There's nothing nefarious about that, nothing unusual at a college party. At around 1 a.m., the defendant and his friends were walking down Franklin Avenue. And Hunter Todd decided to leave that group, and he went into the courtyard, and guess what happened? He wasn't harassed, he wasn't beat up. No, he walked right in. Went to a Sigma Chi party. Imagine that, Sigma Chi and Delta Chi living together harmoniously. Meantime, the defendant and his two remaining friends, Jacob Mike and Shane McConnell, were outside that courtyard area on Franklin Avenue. And Jacob Mike decided to knock on the door, ring the doorbell to that unit where Colin and Nick Peering lived. Now, in Jacob Mike's memory, it wasn't to doorbell ditch anybody, but just to simply find out where Hunter Todd was. Shane McConnell recalled a different event. He thought that it was, in fact, a doorbell ditch situation, that they were going to knock on it and then take off. Either way, they got these people's attention inside, right? And Colin and others came out into the street, and there was a confrontation. Approximately this area. Immediately, it wasn't physical. Immediately, it was simply a verbal confrontation, but Austin Contreras testified that he was there and he was a bystander, and he decided to run up and punch the defendant in the face. Now, he testified, he said that was stupid. Shouldn't have done it. Was caught up in the moment. But he did. He punched the defendant in the face, and that was the only punch, mind you, in the street. Didn't hear any evidence that Colin Brew was doing anything out there or any of the other victims. And after the defendant was punched in the face, his glasses came off and he went where? Into the parking lot, where his car was, where his gun was. And this other group migrated onto that service drive, that sidewalk that was right in front of Mountain View Dorm. And we know this because at Mountain View Dorm, young ladies were watching this happen. And they talked about it as a group of young guys who were arguing. There was nothing physical happening. There were no weapons. Nobody's saying the word kill. And in fact, people described it as the group was dispersing. It looked like it was breaking up. In the meantime, the defendant got this out. Excuse me. There's his car out in the distance. He got this out, the gun. Now you have the gun in evidence. You'll be able to examine it, look at it. And you also have this light. I'm not going to shine in anyone's eyes, but I invite you, if you want to do that in the jury room, to see how bright it was. You heard it talked about during trial as very bright. In fact, people thought it was a police officer or a security guard because of the brightness of the light. It was brighter than any of the lights in that parking lot. Got people's attention. And it came deep from the parking lot. Zach Volpel described it 30 yards in. Surprisingly accurate, because his car was parked 90 feet away from where this happened. Nick Prado described it as a bright light coming from the parking lot. Nobody expected there to be a gun. Not the young ladies in Mountain View, nobody on the sidewalk, not Jacob Mike or Shay McConnell, the defendant's friends who were on that same side of the confrontation. But here the defendant comes through the dark with that bright light. You can't even see where that corner of the parking lot is in this photo. 90 plus feet away. Again, at this time, there was no tightly packed group. That group was actually dispersed, as Jacob Mike described. Jacob Mike even described that he was only in that area at all because he wanted to just get his hat back. That's how dangerous Jacob Mike thought it was, just trying to get his hat. As the defendant approached, you heard that he was shining the light at Colin Brew, meaning his gun was pointed at Colin before there was any movement. None of the witnesses described that Colin was running at the defendant or lunging at the defendant until that light, that gun, was pointed at him. What was the result? The defendant shot Colin twice in the torso. He was unarmed, nothing in his hands, and by all accounts except the defendant's, he didn't say a word. What was Colin supposed to do when there was a bright light shining in his face? Was he supposed to just turn around and run? The defendant never said anything about a gun. You never heard anybody describe that situation. But even if Colin was lunging at the defendant, let's just suppose that that was what happened. He had every right to do so because there was a gun pointed at his face. And this defendant had come from 90 plus feet away to put it there. Next, the defendant shot Nick Peering twice, once through his arm, once in his hip. Again, Nick Peering was not running at the defendant. He was running to get to his friend Colin, who was just shot in front of him. What happened after that? Well, the defendant stopped shooting for a moment. You heard people describe that. He put the gun in the back of his pants. Nick Plecky was watching, and he was thinking, I need to get this gun away from this shooter. I've seen what he's capable of doing. I need to stop this. Nick Plecky, who testified, who was smaller than any of the other witnesses you probably saw during this trial, but had a big heart, wanted to protect his friends. So he went after this gun, and he wasn't able to get the gun. The defendant got the gun out, and he shot several more rounds. And what happened during that second round of shots? The defendant shot Nick Prado, and as Nick Prado testified, he was holding his friend Colin, propping him up. You could see Colin staring into the sky. And he thought to himself, I need to find out what this guy looks like, who the shooter is, so I can tell the police. And so he turned around, he took a step, and he saw the defendant somewhat on the ground, and then he saw the defendant pull the gun out and shoot him through the neck. Now, do you think the defendant was shooting just to get a through-and-through lateral shot in his neck? Of course not. He was shooting at his head. He was looking right at Nick Prado when he shot him. And what did Nick Prado do? He put his hand on his neck, and he ran to the courtyard to get help. And the first officer, the very first officer that found Nick Prado on the kitchen floor, heard him say, very first words, the identifying characteristics of the defendant, of the shooter. That's called corroboration, ladies and gentlemen. He said he was trying to find out what the shooter looked like. The first thing he told the police was what the shooter looked like. Now the defense, during cross-examination of Nick Prado, asked him to turn to page 3 on that 7-page transcript, 7-page interview of Nick Prado at the hospital. Do you see where you say anything about the identifying characteristics of the defendant here? He said no. And then I got up on redirect, asked him to turn to page 4. Do you see where you said it there? Yeah. Nick Prado has been consistent throughout about what he saw, about what happened. The defendant also shot Kyle Zentek. Twice in the back. You heard Kyle testify. His memory isn't great because of the trauma he experienced, but he talked about how a few images stick out in his mind. One image is the image of Colin falling like a statue. Remember that language? Falling like a statue to the ground. And then he recalls how that light was shining on him. And he knew that it was bad, and he turned to run away. And at that moment, the defendant shot him twice in the back. He shot 3 of the 4 victims twice, double tap. That's what he was trained to do, right? Center mass, shoot people twice. Kyle managed to make it down the sidewalk some distance before he collapsed in pain until the paramedics were able to get him to the hospital. He almost died that night. Internal bleeding into his abdomen. This is what actually happened. This is the testimony you heard from many witnesses during this case. The victims who survived this attack. The young ladies in Mountain View dorm. The defendant's own friends, Shay McConnell, Jacob Mike. Now you heard a little different story from the defendant. And not a little different, a lot different, right? Because he got up there and he told you a completely different version of what occurred that night. And so one of the jobs you have as a jury is to determine who's telling you the truth. And how do you tell if someone's telling you the truth or who's lying? Well, the jury instruction tells you that you should use the tests for truthfulness that you would use in everyday life. Use those here in the court. We had a discussion with one of you, I had a discussion in jury selection about that. What was the witness's ability to see or hear or know? What was the defendant's ability to see? And he talked about seeing 90 plus feet away, but he also said he couldn't see past 10 feet. What was his ability to see what was actually happening? What was his manner while testifying? Did it seem like he had some canned answers that was a little rehearsed, kept looking at you, talking about what was going on in his mind? Consider that when you consider the truthfulness of his testimony. Does the defendant have a motive to lie? Well, he's the one on trial. He's the one facing the consequences. You wouldn't expect him to get up there and just admit to everything. This isn't Perry Mason, right? Now he's going to get up there and he's going to tell you a story. He's got a motive to tell you a story. Was he contradicted by anything? We're going to get into that in a few minutes. He was contradicted over and over in this case, and he contradicted himself many times. And what was the reasonableness of his testimony in light of all of the other evidence? Again, look at the outlier. What doesn't fit? What's the one thing that's not like the others? The defendant's testimony. Let's talk about some of his claims. He claimed that everyone is huge, that Colin was way bigger than him. Well, what was the reality? Colin was not bigger than him. He was actually shorter than him. And when I asked the defendant about this, he said, well, he was more muscular than I was. How would he know? He couldn't see past 10 feet. It was so dark. Remember his testimony? Austin Contreras is much smaller. He said he was about 120 pounds at the time when he punched him in the face. Nick Plecky, also smaller. You saw him testify. Ask yourself as I'm going through these, why is the defendant saying these things? Is there some type of motive? Is there a story he's trying to sell you? He said, it was so dark, darker than the photos that the defense put up for you to see. Remember those dark photos? You could barely see, and he said it was even darker than that. Well, what did Detective Rucker say? In fact, you could see better than what was depicted in the photos. And you know this from your own common sense and your experience, that when you take a photo at night with a flash on, it's not going to be exactly like how you see with the naked eye. Everyone else said that they could see. So what's different? Who's the outlier? Now we have in Exhibit 353 body cam footage from one of the officers, and we asked the officer at the time of his testimony, is this what it looked like that night? And he said yes. Let's just take a look at this. This is Exhibit 353. Pay attention to the lighting conditions. There we go, 353. You bet people could see. Look at all the lights on Mountain View Dorm, in the parking lot. You can see down that service drive. When he turns toward the parking lot, you can see in the parking lot. That's how the officer described it that night. A little different than what the defendant said. Let me get back to my slide here. What other claims did the defendant make? He said there were 10 to 12 people attacking them. 10 to 12. A lot more than anyone else said. In fact, the consensus, if you remember the testimony, was 5 to 7. And that at some times included Jacob, Mike, and Shane McConnell in that number. Why does he want you to think that there were more people than there really were? He claimed that people were chasing him. Did anybody describe that? Nobody did. Nobody described anyone going into the parking lot. He said they were really, really fast and sprinting. Strange how they were so fast and yet nobody ever caught him. What did Jacob Mike say? They were sluggish. He could easily outmaneuver them, easily outdistance them. What did their own expert, the defense's expert, say? That at a .285, .208 BAC, you would be sluggish, you would be stuporous. That's consistent with what everyone else said, that they didn't see anybody running after anyone. Defendant claims that he couldn't do many things that night. He couldn't lock his door, he couldn't call the police, he couldn't find his keys, couldn't stay in his car. What was the reality? Well, his fob was in his pocket. He opened the door, he unlocked it, could have locked the door, could have done one of these actions, just click the lock on your door. The reality was his phone was in his pocket, he could have called the police. His keys were in his front pocket. Remember the photos that we showed you, the still photos from that video interview the defendant had with the police? They were right in his front pocket. And not just one key, a bunch of keys. He talked about how he padded his pockets. Nobody at his car. Relatedly, he claimed he didn't have time to react. Well, he had time to get his gun out of his glove box. He had time to get it out of the case. He had time to rack it. He had time to turn on the light. And he knew, and he testified to this, that nobody was at his car. No time to react? Or was he making a choice? The defendant had a hard time taking accountability. Well, I couldn't have done this. I couldn't have done that. You had a choice, and you decided to use your gun. Again, we know he was 90 plus feet from any of the victims in the case. He claimed that there were 10 to 15, or the guys were 10 to 15 feet from his car. Victims were actually 90 plus feet away. Why does he want it to make it sound like people are closer to him? What is he trying to sell you? The defendant claimed that Shay and Jake are in danger. What did they say? Never surrounded. Shay said he didn't run until the defendant showed up with a gun. He didn't want to get shot. He thought the defendant was going crazy. Jake and Mike said it was hostile, but never thought his life was in danger. Shay was afraid of the defendant in that moment. Who was saving Shay and Jacob? Had nothing to do with saving them or getting them out of danger. The defendant claimed that Shay was punched. Of course, Shay said he was never punched. The defendant claims he heard the word kill numerous times and loudly. Did you ever hear anyone else describe that same situation, that someone said the word kill? No. In fact, we asked every single witness who was out there, did you ever hear that word, kill, or any threats? Nobody talked about that. The defendant is the only one, the outlier, the one thing that's not like the others. He claimed that he announced he had a gun several times. Nobody heard that. Nobody heard anything about a gun. In fact, on that last point, nobody thought there was a gun. They just saw a flashlight. Remember, Jacob Mike testified that he only thought it was a gun because of the way the defendant was standing, but he had a lateral view or a side view. People with that light in their eyes had no idea the defendant had a gun. The defendant claims that the victims were moving toward him before pointing the gun. Every other witness describes that the defendant approached the group, the young ladies in Mountain View dorm, people on the ground, the defendant's own friends. He approached the group, he shined the light before there was any movement. And when I say shine the light, I mean he pointed the gun. He claimed that Nick Peering rushed him at the same time as Colin. Now let's just play this out for a minute, because you heard the defendant testify that Colin was rushing at him at the same time as Nick Peering, and that he waited to the last second to shoot Colin. Remember that? And the defense talked about how there was stippling on his neck, which meant that he was 2 feet away or less from the muzzle of that gun. Well, if Colin and Nick Peering were rushing at him at the same time, how did Nick Peering never reach him? It's because that's a lie. There was no rush toward the defendant. Nick Peering testified that he was trying to get to his friend. At no point did he rush at the defendant. And because he was trying to get to his friend, he got shot twice. The defendant claimed that he was piled on by 5 to 10 people. 5 to 10. That's a lot of people. I challenge you, when you get back in the jury room, see if you can fit 10 of you around one person. Why is he trying to make it sound like there were more people attacking him? Jacob Mike says there was one person on the ground. Had him in a headlock. In fact, Nick Plecky testified that that was him. He was trying to get the gun. He said there was maybe 1 or 2 other people trying to help. Nobody describes more than 2 or 3 in that area. Nobody describes this attack like the defendant did. And by the way, this happened after the defendant just shot 2 unarmed kids. They had every right to try to get the gun away from this person who was shooting unarmed people. The defendant claimed he yelled, "Help!" over and over under the pile as loudly as he could. Nobody heard that. He claimed that he was stomped on. Nobody describes that. Injuries inconsistent with being stomped on. That's a violent act. But you saw photos of his injuries. Scratches, scuffed knees. The defendant said he fired in the air. Well, what happened to Nick Prado then? Was he jumping over the defendant at the time? He got shot right through the neck. What happened to Kyle Zentek? He said the light was on him. He was being targeted. He turned around and got shot twice in the back. Was Kyle Zentek jumping over the defendant when he shot straight up in the air as he described? The defense even brought in Amanda Conrad, their witness, to say that she saw him shoot in the air. She's the only person who ever describes this. But when she described it, he's on his feet, nobody around him, nobody attacking him. Now, there are 7 bullets that can be accounted for in this case, out of the 10 that were fired. Remember, there are 10 shell casings at the scene. 7 of them ended up in the victims in this case. 2 into Colin Brew, 2 into Nick Peering, 1 into Nick Prado, and 2 into Kyle Zentek. 7 bullets, 7 out of 10. 70% accuracy, that's pretty good. Is Manacondra talking about something that happened after he targeted Nick Prado and Kyle Zentek? Maybe. But at any rate, he's not being piled on, he's not being attacked when he's shooting in the air. And of course, we had the physical evidence to contradict this story by the defendant. The defendant claimed that a guy had a rock or a bottle. Nobody sees anyone with a weapon, including his own friends, Shane McCall and Jacob Mike. Never described this. The defendant said this group was tightly packed. What did everyone else say about this group? At the point that it was on the sidewalk, people were dispersed, it was spread out. Jacob Mike described this, Shane McCall described this. There was no one being surrounded. Why is the defendant saying these things? What is he trying to sell you? The defendant claimed that he could see. Now, we're getting into contradictions in his own testimony now. Okay, this isn't what we just talked about, where things that he was contradicted by all the other evidence in the case and by the witnesses. But here he contradicts himself, right? He says he could see the group 90 plus feet in the dark without his glasses. And the defense got him, when he was on the stand, got him to read a passage where he stated to the police that he couldn't see past 10 feet without his glasses. That's what you call convenient eyesight. See only what you want to see. Or you're claiming that you can see things that you really can't see because it helps your story. The defendant claimed that he shot Colin and Peering and put the gun away. Weird then that he said his friends were surrounded by all these dangerous people. Why would you put your gun away if you're being attacked by 10 to 12 people? Could it be that that's a lie? He claimed that he shot in the air when he was piled on. Again, why did he shoot Colin and Nick Peering, people who never put a hand on him, and then he decided not to shoot people who were piling on him and stomping on him? Does that make any sense? The defendant claimed that, and this is a big one, he claimed this to the police over and over again. When I cross-examined him, he admitted probably 7 different times. He said that he was right outside his car when he shot Colin and Nick Peering. Because they were right there, sprinting at him, rushing at him. Over and over he says that. And then in trial he says, well, it was actually 90 plus feet away. He conceded that. Why? Because he just seen all the evidence. Every single witness described that this occurred in the corner of that parking lot. The physical evidence is right there. He can't say that they were right at his car. But why would he say that to the police? Why would he want to tell them that they were right at his car? Does that help bolster some type of claim he's trying to make that didn't exist? He claimed that he walked across the parking lot to protect Jake and Shay. This is a new story he was telling us, because he also said, again, to the police that he was just a few feet away from his car when he shot to protect himself. Now, one of you asked a question when the defendant was on the stand, one of the jury questions, and it was a great question because it asked, why did you feel you needed to approach the group in the corner of the parking lot after you got your gun? That was the question. And I wrote down his response. Here's what the defendant testified to on that point. When I looked left after I had the gun, I still saw those 2 guys, and they were still looking at me, I think. I could only see silhouettes, but they were still coming at me. And I couldn't just abandon my friends anyway, even if no one was coming toward me. I still couldn't ditch my friends and leave them there to get pummeled on the street by strangers. So it was kind of a mix of everything, I guess. Those are his words. Now let's break this down for a minute. He says, when I looked left, I saw the 2 guys, they were still coming at me. He's 90 plus feet away. And he's saying he could see 2 guys coming at him. If they were rushing at him, sprinting at him, as he described, how did they not move any distance? How did he go 90 feet walking and they didn't move an inch? Then he says, he pivots. He says, and I just couldn't abandon my friends anyway, even if no one was coming towards me. He's admitting that, in fact, there was no one coming towards him right here. He realizes, in the moment he's giving this answer, that he couldn't have it both ways. He can't say that they were rushing at him when he's at his car and also go 90 feet to protect his friends. And so what is the last thing he says? So it was kind of a mix of everything, I guess. The defendant is throwing things up against the wall to see what will stick. Well, if I wasn't at my car protecting myself, maybe I was 90 feet away to protect my friends. I don't know. It was a mix of everything. Now, when I sit down, the defense will have an opportunity to argue to you, and let's just pay attention to see if what they argue is going to be a mix of everything. What do all these lies have in common? These claims the defendant makes that are inconsistent with all the evidence, with everyone else's testimony, what do these all have in common? Things like, there are 10 to 12 people, everyone is huge, they're rushing at me, they're sprinting at me, they're telling they're going to kill me. Again, things that are totally contradicted by everyone else in the case. What do these have in common? They are all trying to bolster a self-defense claim that does not exist. Luckily, we do not have to rely on the defendant's statement because you have 15, 16 witnesses who were there, who saw what was happening, who witnessed it firsthand, that contradict what the defendant's story is. You see, the defendant can't tell you the truth because it was not self-defense. It was retaliation, and he knows it. And if it's retaliation, ladies and gentlemen, the defendant is guilty of first-degree murder. Now, the defendant is charged with other counts, 6 other counts, in fact, of aggravated assault. And there are different versions of aggravated assault. Let's go over this real quick. Aggravated assault on counts 3, 5, and 7 say that the state has to prove that the defendant intentionally, knowingly, or recklessly, these are the mental states that have to be proved, caused serious physical injury to Nick Peering, Nick Prado, and Kyle Zentek. As to the first point, you heard testimony from the defendant himself, in fact, that he intentionally shot Nick Peering. So go ahead and check that right off. You also heard from Nick Prado that the defendant looked at him before he shot him. Does that show intent? Does that show that he knew what he was doing? Of course. Kyle Zentek similarly talked about how the light was pointed at him. And that when he turned, he was shot twice. Does the fact that he shot twice at Kyle Zentek show intent? Absolutely. Again, remember the intent inference instruction, that you can infer intent based on all the facts and circumstances. Did he cause serious physical injury to Nick Peering, Nick Prado, and Kyle Zentek? Well, as to Nick Peering, you heard him testify that he was shot twice. Serious physical injury is defined in your instructions as injury that has a risk of causing death or also causes permanent disfigurement. Gunshot wounds, scarring, permanent disfigurement from these big bullets. It also tells you that it can be a protracted loss of limb or bodily function. Nick Peering testified that he still suffers from muscle spasms to this day because of what happened. Nick Prado likewise testified that that shot to his neck gave him some nerve damage. He had to have post-surgery after that first hospital visit. Talks about even today that he has complications from that. He couldn't lift his arm up because of that. Serious physical injury. Kyle Zentek, he almost died. He lost a kidney. You saw the scarring on his stomach from the surgeries that they had to do to save his life. You can check both of these off. Now, counts 2, 4, and 6 talk about how the defendant intentionally, knowingly, or recklessly, again, the same mental states, caused any physical injury. Again, this is not serious, but just any physical injury at all. And he did it using a gun. There is no dispute that he used a gun. And as before, the defendant knew what he was doing. He was targeting these victims when he shot them. The defendant is guilty on all of the counts. Thank you. I know I've talked a long time, but let me leave you with this. Sometimes when we come into court, there's this idea or this tendency to think that your common sense, your reason, your experience isn't good enough for the court system. Because, let's face it, this is a weird system where we have people take the stand one at a time. There's objections that are sustained or overruled. We have secret conferences with the judge. And so sometimes there's a tendency to think that my common sense isn't good enough. I got to change my thinking somehow. I got to think differently because this is a different system. But the jury instructions tell you that's the opposite of what we want you to do. We want you to bring in your common sense, your reason, and your experience. Because the only way this system works is if you do that, if you bring your common sense into this system. It's because of you that this system works. We don't impanel 12 judges or 12 lawyers to make these decisions. We get people from the community bringing in their common sense and their experience to determine what actually happened. And what actually happened that night, the state has proven to you over and over through the witnesses in this case. What actually happened was that the defendant wanted to show people that he had the power. And he knew he could do that with that gun in his hand. And the first person who decided to confront him, who dared confront him and challenge him, Colin Brew, he decided to shoot twice in the torso. Killed him in the rocks. Colin Brew was 20 years old. You heard Amanda Conrad talk about his friendship with her. You heard about how his friends tried to come to his aid when they saw him on the ground. It's tragic. There's nothing we can do now to bring Colin back. There's nothing we can do now to stop what the defendant did that night. But there's something that you can do today, right now, to find this defendant, Stephen Jones, accountable for what he did and find him guilty on all of the charges. Thank you.
Thank you, Mr. Barker. Folks, let's stand at recess for 10 minutes. Please remember the admonition.